Welcome back to the deep dive. We're continuing our journey through the MPOP section by section. Today we're in Chapter 1200, which is all about appeals. And specifically, we're zoning in on MPEP Section 1216. That's the one covering judicial review. So the big question is, what happens after the PTP, the Patent Trial and Appeal Board, makes a final call and, well, you don't agree, how do you take that fight to the courts? Section 1216 basically maps that out for you.
Yeah, it's a critical stage. Often, this is really your last shot at challenging a USPTO decision in the court system. So knowing the rules, the paths available, it's essential, and Section 1216 lays it all out.
Okay, so set the scene. Who are we talking about here? Who uses this section?
Right. So 1216 kicks in when you're a party involved in the USPTO. Maybe you're an applicant trying to get a patent. Or perhaps you're a patent owner defending your patent in, say, a post-grant proceeding or maybe some other participant.
Yeah.
And the key trigger is that the PTAB has issued a final decision. And you, the dissatisfied party, want to challenge it further.
Okay, got it. So PTTB decision is in. What are the options laid out in 1216?
Well, fundamentally, the section points to two main routes for judicial review. First, you can appeal directly to the U.S. Court of Appeals for the Federal Circuit. That's under the statute 35 U.S.C. Section 141. The second main option is to file a civil action. This isn't an appeal in the same sense. You'd file this lawsuit against the director of the USPTO, and it goes to a specific court, the U.S. District Court for the Eastern District of Virginia, and that's governed by either Section 145 or Section 146 of 35 U.S.C., depending on the type of underlying PTA proceeding.
Okay, federal circuit appeal or a civil action in the district court, but then the section says something really important, doesn't it, about choosing?
It does, and this is absolutely critical. MPP 1216 makes it very clear. You pick one path and only one. If you file that appeal to the Federal Circuit under Section 141, you waive your right to later file a civil action under Section 145.
Wow. Okay, so you can't take two bites at the apple. You choose your court, and that's it. Why is that choice so significant? What's the practical difference?
It's a huge strategic decision. The main reason comes down to how each court generally reviews the PTA's decision. The Federal Circuit appeal under Section 141, that's typically based entirely on the existing record, meaning the court looks at the evidence and arguments that were presented to the PTA. They're checking for legal errors or if the PT findings were supported by the evidence in that record.
Okay, so they're reviewing the game tape, essentially.
Pretty much, yeah. Now, the civil action in the district court under Section 145 or 146, that can be different. While you're still challenging the PT decision, there's a possibility, depending on the circumstances, that you might be able to introduce new evidence that wasn't before the PTP.
Okay. So the district court might let you bring in something fresh, whereas the Federal Circuit is generally stuck with what the PT tape already saw.
Exactly. It's not guaranteed you can bring in new evidence in the district court, but the potential is there. That difference, record-only review versus potential for new evidence, is often the core strategic factor when choosing the path.
Makes sense. And the MPP explicitly states filing the 141 appeal waives the 145 action. No ambiguity there.
Not at all. And 1216 also clarifies which path applies to different proceedings. For instance, for post-grant reviews, PGRs, inter partes reviews, IPRs, and even ex parte reexaminations, the only option for judicial review mentioned is that Section 141 appeal to the Federal Circuit. But interestingly, for derivation proceedings, Section 1216 notes that an adverse party actually can choose to force the issue into a civil action under Section 146, even if the other party appealed to the Federal Circuit initially. That election has its own specific deadlines, too.
Okay, so the type of PTAB case can dictate your options or lack thereof. It's complicated.
It definitely requires careful attention to the specifics of your situation.
Right, so you've made this huge strategic choice about where to go. What about when? I imagine the deadlines are pretty unforgiving.
Unforgiving is a good word.
Yeah.
Yes, timeliness is paramount. Section 1216 is very explicit. For the Federal Circuit appeal under Section 141, the general rule is you must file your notice of appeal with the USPTO within 63 days.
63 days? That's not a lot of time, starting from the date of the final PTAB decision.
Exactly. 63 days from the board's final decision date. And getting an extension. Possible, but only for good cause or excusable neglect. You really shouldn't count on getting one.
Okay, 63 days. What if you ask the PTB to reconsider first? A request for rehearing.
Good point. If you file a timely request for rehearing with the PT, that does reset the clock. The 63-day period for the Federal Circuit appeal then starts running from the date the PT issues its decision on that rehearing request.
Okay, so that buys you some time, potentially.
It can, but crucially, the MPP says this reset only happens once. You can't keep filing rehearing requests to indefinitely postpone the appeal deadline.
Got it. One reset max. What about the civil action route, Section 145 or 146? Similar tight deadlines.
Yes, there are strict time limits there too, generally also tied to that 63-day window or the rehearing decision date. And for the civil action, it's not just filing the complaint in the district court. Section 1216 reminds practitioners they also have to follow the federal rules of civil procedure for serving the complaint. That means properly delivering it to all the required parties, which specifically includes the USPTO Director and also the U.S. Attorney General. Getting that service right and on time is absolutely essential.
Okay, so navigate the choice, hit the deadlines precisely. Now, let's say you've done all that. The court, federal circuit, or district court rules. What happens next, back at the patent office?
Right. Section 1216 provides some examples of the downstream effects. Let's take a common scenario. The PTAB rejected all the claims in your application. You appeal to the federal circuit. The federal circuit affirms the PT's rejection. In that case, according to the MPP, the application is basically considered terminated. It's over.
No chance to fix things.
Generally, no revival unless,
Yeah.
crucially, you had already filed something like a continuation application before everything became final.
Ouch. Okay, what if the court decision is more favorable? Maybe they reverse the PTAB on some claims.
That's a different story. If the court finds some claims allowable or reverses the rejection, the case goes back. The USPTO might then proceed to issue the patent with those allowed claims, or, depending on the specifics of the court's decision, they might give the applicant a chance to amend the claims consistent with the ruling.
So the court's decision really dictates the next steps at the USPTO.
Absolutely. And there are specific procedures. The USPTO gets the official court order, the certified mandate, and puts it in the file record. And importantly, the USPTO only gets jurisdiction back to actually do something with the application, like examine amendments, if the court specifically remanded the case back to the agency for further action.
So if the court just affirms or reverses without sending it back for more work, the USPTO's hands might be tied.
Largely, yes. And filing amendments after a court decision isn't usually allowed unless the court order permits it, or there's some specific rule allowing it in that posture.
What if the appeal just fizzles out? Like it gets dismissed for procedural reasons or the appellant withdraws it?
Section 1216 covers that too.
Yeah.
If an appeal is dismissed, the status of the application really depends on why it was dismissed and what the underlying situation was.
Yeah.
Often, though, dismissal can lead to the application being held abandoned unless there were already claims deemed allowable separate from the issues that were on appeal.
So dropping the appeal isn't necessarily a neutral act. It can have real consequences.
Definitely. It usually defaults back to the PT decision becoming final.
Okay. It seems like Section 1216 is really about drawing very clear lines in the sand.
That's a good way to put it. Its purpose is to ensure these routes for judicial review are precisely defined, legally grounded, and crucially, procedurally disciplined. It spells out the how, the where, and the when.
And for you, the listener, understanding these pathways, the critical choices, and especially those non-negotiable deadlines, it's fundamental if you ever find yourself needing to challenge a PTAB decision and want to make sure you actually preserve your right to do so. We also want to give a special thank you to Mike Shepard. He's the creative director who organized this whole MPP audio series. We really appreciate his work in making these deep dives happen. So here's something to think about. We've talked about these strict deadlines, 63 days, and the huge strategic choice between the federal circuit's record review and the district court's potential for new evidence. How does this level of detailed procedure in Section 1216 actually impact your real-world chances of successfully overturning a PTAB decision and getting or keeping your patent rights through the courts? It seems like procedure is substance here.
That's a great question to ponder. And just before we wrap up, the necessary disclaimer. This summary was generated using AI tools, specifically ChatGPT and NotebookLM, based on the MPP text. It might contain errors or leave things out. It's intended for general educational and informational use only. It is definitely not legal advice, nor is it a substitute for formal training. For authoritative guidance, you always need to consult the official MPP, talk to a qualified instructor, or seek advice from a registered patent practitioner.
Absolutely essential reminder. Thanks for joining us on this exploration of MPP Section 1216 on judicial review. We'll be back soon to tackle another section.